will focus on the policy and procedure document in this segment. Policies and procedures form an essential part of an AML CFT compliance program, addressing key issues such as risk appetite, and must be designed to achieve compliance with AML CFT legislation and guidelines. Financial Action Task Force Recommendation 1.1 states that financial institutions and DNFBPs should be required to have policies and procedures which are approved by senior management to enable them to manage and mitigate the risks that have been identified, either by the country or the financial institution or DNFBP, monitor the implementation of these controls and to enhance them if necessary, take enhanced measures to manage and mitigate the risks where higher risks are identified. The policies and procedure document should, at a minimum, cover the following requirements. It should be written and should be in a format to ensure that it is accessible to relevant staff and the supervisory authority. Kept up to date, several factors could trigger the need to update the policy and procedure document, such as changes in legislation, non-compliance issues, new services or products, or deficiencies identified in the firm's internal compliance review. These factors are critical to ensuring that your KYC and KYE remains on trend. Senior management must approve the document by stating approval and assigning signature and date to the document. The supervisory authority expects the written policy and procedure document to outline the obligations applicable to the relevant business under the AML legislation and associated regulations, and the corresponding process and controls the firm has in place, including stating when obligations are triggered, the information that must be documented and retained, the procedures created by the firm to fulfill the required obligations, and the timeliness associated with the obligations and methods of reporting. The policy and procedure document also helps demonstrate your commitment to prevent, detect, and address non-compliance. Risk assessment activities, including the risk mitigation measures used. A risk assessment is an analysis of potential risks and vulnerabilities that can expose a business to money laundering, terrorist financing activities. This assessment must identify the business inherent risks and develop the appropriate measures to mitigate and manage these risks. Enhanced measures must be developed for high-risk clients, products and services. Example, additional information on the source of funds and source of wealth of the customer, additional information about occupation, beneficial owners, nature of the business, domicile verification visits, banking references, approval of senior management to establish relationships, explanation of changes in account activity, and enhanced monitoring levels and thresholds. The risk assessment must be reviewed and updated when there's a material change to the business, service offerings or technology or delivery mechanisms, or client base, or when deficiencies in the effectiveness of the risk assessment have been identified. Examples of triggers for an updating of the risk assessment include when a national risk assessment is published, a sector risk assessment published by the supervisory authority, a change in legislation, or an international money laundering, terrorist financing related event. The risk assessment should be documented and demonstrate to the supervisory authority that you have identified, assessed, and addressed the money laundering, terrorist financing risks related to customers, countries, geographical areas, products, services, transactions, and delivery channels. Each business has unique circumstances that determine their exposure to money laundering, terrorist financing risks, which need to be understood and factored into their unique AML CFT program. A documented ongoing compliance training program for relevant staff on what are the firm's AML CFT obligations, how to implement the policies and procedures, and measures to ensure high standards before hiring. The training program must be reviewed and kept up to date and include money laundering terrorist financing methods, vulnerability and trends related to the business and profession, money laundering terrorist financing concepts, regulations, internal controls, how the policy and procedure document prevents and detects money laundering terrorist financing, including reporting suspicious transaction activities or transactions or large cash transactions. In addition, the recognition and handling of suspicious transactions, client identification, KYC, and record-keeping obligations. All relevant staff authorized to act on the business behalf who deal with clients and on transactions must be trained in relation to their duties and understand how the business and profession could be vulnerable to money laundering terrorist financing activities. Members of staff who are dealing directly with the public are the first point of contact with potential money launderers, and their efforts are therefore vital to the organization's reporting system for such transactions. A higher level of instruction covering all aspects of money laundering procedures should be provided to those who are responsible for supervising or managing staff. This will include the offenses and penalties arising from the relevant AML CFT legislation for non-reporting and for assisting money launderers. Whenever staff members attend AML CFT training, including the training today, the type of training and attendees must be documented. Training must be conducted for new employees during the onboarding program and at least once a year for all employees, and that's required by law. Staff members should sign a confirmation document that they have read the training material that they are expected to be familiar with. The screening process for hiring new employees should seek to ensure that employees do not perform any function that cause harm in relation to the execution of the function for the firm. To this end, the firm's screening process for the employees must allow the firm to be comfortable with the employee's personal character, honest integrity and reputation, competence, ability to effectively execute the functions of the position, qualifications that require experience, knowledge, and training. The screening process should also include, but is not limited to, background and employment historical checks, police record reference checks, including character and financial references or equivalent, and qualifications. For all employees, continued monitoring is encouraged to ensure they remain fit for employment. Employees should consider monitoring employees who are suspected of being linked to unusual transaction activities, unusual increase in business activities, and persons known to be involved in illegal activities or associated with individuals of questionable character. The most effective Know Your Employee program should be complemented by a sound ongoing training program which includes staff awareness. Training is a key pillar of the compliance program, and the training content, coverage, and frequency should reflect the knowledge required. An internal compliance review, which assesses the adequacy and effectiveness of the compliance program, including the policy and procedure, document, the risk assessment, and ongoing training programs. In addition, examples of what could be included in the review include the procedures for record keeping and suspicious transaction reporting, taking samples of clients to determine if the enhanced mitigation measures for high-risk clients were taken, if the risk assessment for a sample of clients was applied correctly, the frequency of ongoing monitoring is adequate, and if the written AML CFT policy and procedures meeting the obligations of the legislation and guidelines, including any updates and amendments. Interviews with those handling transactions to evaluate their knowledge of your policies and procedures and related record-keeping, client identification, and reporting obligation. In addition, a sample of large cash transactions followed by a review that the relevant procedures were applied and a sample of account opening records followed by a review of the procedures. The internal compliance review must address whether the policy and procedures, risk assessment and training program are effective, and whether practices comply with the legislative and regulatory requirements. We recommend that businesses should conduct an internal compliance review at least once a year. The findings of the review must be documented and the cause of deficiencies identified corrected. The internal compliance review and any updates and deficiencies must be submitted to senior management and be available for review by the supervisory authority. Know your client procedures and other requirements such as verifying client identity, PEPs, family members and associates, heads of international organizations, beneficial ownership, third-party determination. Proper KYC is one of the best methods to prevent money laundering and terrorist financing risk. Transactions, verification and record-keeping procedures, state obligation to keep transaction identification and verification records, and the information and documents that would be kept as required by law. Statehood records would be kept, format, and for how long. In addition, the procedures for relying on third parties to conduct CDD, the business remains responsible for ensuring that the required CDD is conducted in accordance with the relevant AML CFT Act, and that's the FTRA. The procedure for ongoing monitoring of customer transactions and any special measures implemented based on the risk assessment, for example, taking enhanced measures to verify the identity or confirm the existence of high-risk clients, enhanced measures to keep client information up to date, enhanced measures to keep beneficial ownership up to date, and taking any other enhanced measures to mitigate the risks identified. This should be undertaken during the client onboarding and on an ongoing basis. The firm must document the procedure for handling ministerial directives and transaction restrictions, which are targeted measures issued by the relevant competent authority to protect the country's financial system from being used for money laundering, terrorist financing purposes. This would include compliance with United Nations Security Council resolutions and requirements for financial institutions to cross-check and apply a risk-based approach to determine whether any customer or beneficiary appears on any designated list issued in compliance with any designated list on targeted financial sanctions related to terrorism, terrorism financing, and proliferation of weapons of mass destruction, and its financing, and report this information to the competent authority as per the applicable legislation, and in our case, that's the FIU. Document the procedure for applying enhanced due diligence measures to business relationships and transactions with natural and legal persons and financial institutions from countries which Financial Action Task Force stipulates as high-risk countries. The type of enhanced due diligence applied should be effective and proportional to the risks identified. Information regarding advice and concerns about weaknesses in the AML systems of other countries can be obtained from the Financial Action Task Force website. Define and state the functions of the MLRO and the compliance officer and responsibilities of management and staff as appropriate. The compliance officer is responsible for effectively implementing all of the elements within the compliance program: policies and procedures, ongoing training, risk assessment, and the internal compliance review. The compliance officer needs to have the necessary authority, knowledge, and access to resources in order to implement an effective compliance program. In the Bahamas, DNFBPs are required to appoint a money laundering reporting officer as point of contact with the FIU to handle reports of money laundering suspicions by their staff. The person appointed as the MLRO has a significant responsibility to the firm and should be sufficiently senior to exercise the necessary authority competent and familiar with statute laws governing the business. The size and nature of the firm should be a determining factor in selecting the individual to hold the position. Larger businesses may choose to appoint as appropriate to the circumstances a senior member of their compliance department. In small firms, it may be appropriate to designate the sole practitioner or one of the partners. When several subsidiaries operate closely together within a group, designating a single MLRO at a group level is an option. The MLRO should exercise independence when determining whether the information or other matters contained in the transaction report he or she has received give rise to a knowledge or suspicion that someone is engaged in money laundering, terrorist and/or proliferation financing. The firm may choose to combine the roles of the compliance officer with the MLRO, depending upon the size and nature of prescribed services that is involved. State the applicable AML CFT laws and guidelines and commit to adhere to them. Importantly, the level of detail in your policies and procedures depends on the size, structure, and complexity of the business, and the level of exposure to money laundering, terrorist financing risks. For example, the compliance policy and procedure of a small business may be less complex than that of a large business. However, the policy and procedures must be tailored to the specific business and its inherent requirements, clientele, geographical regions, products, etc. The policy and procedure sets out the standards that employees, agents, and anyone authorized to act on a company's behalf must meet. These standards must be understood, adhered to, and be easily accessible by all relevant staff. The relevant staff must know the policies. For example, what is required to identify clients, keep records, enhance due diligence procedures, knowledgeable regarding the obligations in accordance with the AML CFT laws, and red flags to recognize, assess, escalate, and report suspicious transactions. The relevant staff needs enough information to process and complete a transaction and account opening properly, as well as identify customers and keep records as required. The policy and procedures analyzed by the supervisory authority to ensure their completeness, approve or recommend amendments of any deficiencies if identified, and expect that firms will be able to demonstrate how they are effectively implemented during an examination. Although directors and senior officers may not be involved in the daily compliance program, they must understand the legal obligations placed on them, their staff, and the entity itself. Management must prioritize and popularize a company-wide culture of AML CFT compliance by setting an example to the rest of the company and promoting ethical behavior. Finally, our recently passed FTRA includes the requirement for DNFPPs to implement procedures for the prevention of activities related to identified risks, terrorism or financing of terrorism, or such risks as the minister may prescribe by regulation.